Welcome, members. We are seeing quite a number are still coming in. We encourage you to log in. Karibuni sana. This is our second webinar, and we are so happy to see you guys coming in and joining us during this webinar. So karibuni sana. Just before we have our executive director coming in, we will allow those participants who are still coming in to come in. So just come in. We'll start shortly. Those who are coming in, please continue to come in. We are just about to start. Thank you, Alice. I can see you there. Hussein, karibu sana. Geoffrey, karibuni sana. Even as we begin our second webinar, I want to take us through the program of the day, where we'll be able to appreciate and see what we are going to cover today. I believe, members, you can see the program. We will have our opening remarks from the Executive Director, Mrs. Jacqueline Mugo, who will take us through an overview of what is going on in the market. We are also going to have a presentation. Many of the questions that we've received from you members are on how we can manage the employment contracts during this COVID-19 pandemic. And therefore, we are going to look at quite a number of concepts, quite a number of doctrines that are out there. And then, of course, we will address your questions and answers, some of which you've been sending throughout the week, some of which we've received also this morning. And then we will finally have our closing remarks from our Executive Director. So today, we are going to look at managing employment contracts during the corona pandemic and what strategies and approaches employers can adapt even during these tough times. So I'm very pleased and I'm very honored to invite our Executive Director, Mrs. Jacqueline Mugo, to address you and even to give us an overview of what is going on and what are some of the things that FKE is doing for you and how can you come in and even join us even in this fight during this time of coronavirus. Karibu sana, Mrs. Jacqueline Mugo.
Good morning, members. I want to welcome you all very warmly to this session. This is the second webinar we are conducting. And today we want to look specifically into one issue that has been causing a lot of problems to you and on which, as Grace says, we've received a lot of questions. First, I'd like to give you a snapshot. I'd like to give you first a snapshot of what is happening at the global level in this crisis, because indications are that the whole world has been impacted by the coronavirus, and the labor market in particular is going to be impacted negatively. We also want to share with you what FKE has done in terms of supporting you as our members and the action we've taken. We want to invite you as members to participate in the fight against COVID-19 and to contribute to the same. And at the end, I'll be sharing very briefly the future engagements that we hope to have with you. If you look at the global scene, COVID-19 is clearly both a health and a human crisis. It will have socio-economic impacts, huge socio-economic impacts, including on the labor market. According to ILO estimates, there is already a sharp rise in global unemployment, and this could rise to as high as 25 million people being out of work, or people being forced out of formal employment as we know it, and even formal employment, because informal businesses cannot operate at this time because of the shrink down in economic activity. So the indications are that millions will be forced into unemployment, underemployment, and what we call in labor market speak, working poverty. You're working, but you're actually poor because what you're taking home at the end of the day cannot allow you to make ends meet. We also see a sharp decline in wages due to the reduced hours of work and also reduced business operations. Hence, there is a correlated reduction in the consumption of goods and services, which is detrimental to enterprises, and a lot of companies are at risk of collapsing, and very many have collapsed. In fact, yesterday we were learning that a country like Spain, where the COVID-19 impact is huge, more than 200 businesses have already gone out of operation. As we speak, 68% of the countries globally have some form of lockdown or quarantine, which means there's a drop in human mobility and also a drop in activities. The greatest impact is on what we call vulnerable groups. These are older people. Indications of that the COVID-19 impacts very gravely older people. But of course, even in Kenya, we are seeing younger people are also involved, impacted. It also adversely affects those with underlying health conditions, those who are unemployed and were already vulnerable, women in particular, and the UN is taking a special interest on women and what can be done to protect them at this time because they are a vulnerable group, on those who are unprotected in terms of working without protection, and migrant workers. So globally, there's a sharp increase in vulnerability, and the greater concern is that most countries do not have social protection schemes or arrangements in place. On our part as a federation, and as we shared last week, we want to reemphasize our commitment to helping you as members to cope with the impact of COVID-19, but there is also an increasing realization of the need to internationalize the global response to what is actually a global crisis. There is need to focus on national priorities as we are doing, but there's a global element to it because we know as the world, we're increasingly smaller and this crisis is affecting the whole world. So Kenya cannot recover on her own without having an impact on the rest of the world, without collaborating with the rest of the world. So conversations that we'll be having in future is how do we participate in this international arena as we focus, of course, on the immediate challenges of what's happening in the country. The labor sector in this regard has called for innovative and flexible approaches to employment. Employment as we know it has changed. There is a sharp call for global emergency fund to support business continuity, especially the SMEs. So here we are very happy that a fund has been created to help Kenyan businesses and Kenyans at large to cope. and we have invited members to contribute to this fund. FKE is part of this global conversation, and we want to reaffirm our commitment to supporting you members, but also to availing information to you so that you can benchmark and you can see what's happening in the rest of the world, because we do have those international networks through the International Organization of Employers and the International Labour Organization. So what has the Federation of Kenya Employers done since this crisis came upon us? We have written and sent to you various advisories and guidelines to you members on a whole spectrum of issues in terms of managing COVID-19 at the workplace. And we do hope that you are implementing these, and please stay engaged with us and let us know any ideas or challenges you may be having. We have engaged with you through webinars such as this. We are also learning, just as everybody else is, and we're very proud to be able to engage with you through these webinars. Please do send to us any ideas you have in terms of topics and subjects you want us to discuss going forward, because this will be the modus operandi in the next few months. We've attended and organized a number of meetings, high-level tripartite engagement meetings with our social partners, looking at solutions to mitigating the effects of COVID-19 at the workplace, and in particular on employment contracts and on employment. We have prepared and sent memorandums to both our Ministry of Labour and Social Protection and lately to Parliament on the Tax Laws Amendment Bill 2020, which had a whole raft of proposals and changes, some of which are far-reaching on new members, and we'd invite you to study this Tax Laws Amendment Bill and have your inputs. You can send them to us, although the deadline is up, but I'm sure in these strange times, we can still send them to Parliament so that all voices are heard. We will also continue to engage with government and with you and with other business member associations, so that together, as we keep track of what is happening, keep giving ideas and proposals on how to help not just business to cope, but Kenyans as a whole. We're happy to say that the Federation is part of what we call a rapid response team, which was formed by the Ministry of Labour to track COVID-19 development and its impact at the workplace, and to continue giving proposals on what needs to be done, and also share data on good initiatives which industry may be implementing, and also how to collaborate better with the Ministry of Labour and Social Protection, particularly in addressing occupational health and safety issues at the workplace for the skeleton staff who we know are still coming to work in some of our enterprises. We have engaged with the media regularly, most of the TV channels and even on radio, to discuss what employers are experiencing and also to share with other Kenyans what we are doing. So we are here for you members, and we want to keep engaging, and we are very happy that you've taken time to come and participate in this second webinar, where we are focusing especially on the employment contract. What innovative approaches can employers have in managing the employment contract, which by and large has collapsed as we know it, because people are at home trying to protect themselves from COVID-19. But what is the obligation of the employer in these times? What are some of the options that we have? So this is what we'll be sharing with you. And I'm very happy to invite Grace, who is our head of industrial relations and labor services, to share with you this topic, and then we'll open it up to engagement. Thank you.
Thank you very much, our Executive Director, Mrs. Mugo. That was a wonderful presentation on what is going on in the world, and we are very grateful even for you to address our members and reach to them. We will now look at the presentation that we have that addresses how to manage contracts even during this time. And many members have been asking, and therefore we want to share with you what strategies and approaches employers can engage even during this COVID-19 pandemic. Before we look at the strategies that you can implement or the strategies that you can adapt, we must look at the type of contracts that employers have and what it means to have different kind of contracts. We're also going to look at frustration of contracts, or what many of you have been asking about force majeure. We are also going to look at managing terms and conditions of employment. Many of you have talked about reduction of pay, or what is commonly known as pay cuts, now allowances, benefits, reduction of these things. One of the types of contracts that we have different kind of contracts, are casual contracts, we have piece rate contracts, task rate contracts, foreign contracts, fixed term contracts, regular, or what we normally call P&P contracts. And each one of these contracts, because of the nature of the contract, the nature of work, and the terms and conditions of that contract, they have different approaches, and the coronavirus pandemic has an impact, a very different impact on the different kind of contracts. We'll first start with, of course, the simple contracts, which why I call them simple is because they are flexible, they're easy to manage. These are the casual contracts, the piece rate contracts, the task rate contracts. There are many employers, and I hope none of you are those employers who have abused really casual contracts. Casual contracts are the kind of contracts that an employee is paid at the end of the day. That is what the law provides. And these casual contracts should not extend beyond 90 days. Meaning, if you need somebody to come and cut your grass, they cut your grass at the end of that day, you pay them. So for casual contracts during this COVID-19 pandemic, they would be easy to manage because you pay somebody at the end of the day and they are gone. So your obligation to those kind of workers during this time is really to ensure that they are working in a safe environment, if at all you need these workers to be working. Piece rate workers, we have packers, we have loaders who come to the factory, do the work, and are also paid either at the end of the day or at the end of the week, depending on the kind of arrangement that you have with these workers. Again, it's to ensure that the working arrangement is safe, and to ensure, of course, that they are paid for the work that they do. And these are simple contracts because they are flexible, they may not need to come every day, and they're easy to mitigate during this time. They're easy to work out during this time. And task rate, of course, these are the ones that an employee is paid at the end of that task. And depending on how they need to work during this time, it's of course to ensure that the workstation or the work environment is safe for them. Foreign contracts are generally defined as contracts that are fully or partly implemented outside Kenya. Of course, the corona pandemic has really affected a lot of foreign contracts because there's a prohibition, or there are prohibitions on travel. You have seen that our airlines are not moving. So it means that many employees could be stuck in the countries where they work, or they came back home and they're not able now to execute the terms and conditions of service under their contracts. So because of this kind of contract, we are advising employers to really look at the terms of that contract. What are the terms of that foreign contract? What does it provide for? Many foreign contracts, which are well drafted, have perhaps provisions for force majeure, and therefore that would cover that kind of circumstance. But where we have contracts perhaps which do not have that clause, then we are now at a very interesting time, because we'll need to see how that contract can be managed even during this pandemic period. We also have fixed term contracts, and under fixed term contracts, we know that when we began the year, many of us as employers were very optimistic, and so we had some people who are at the probationary contracts. And in probationary contracts, how then do we manage that kind of a contract? It is a little bit simple because probation is usually a time of perhaps testing skills and seeing whether an employee can be confirmed because they're able to deliver. And this pandemic perhaps has now caused employers to be unable to deliver, or employees to be unable to deliver. And therefore, for this kind of contracts, depending on the terms that are contained in that contract, There are many employers then who might be constrained not to confirm those contracts and to wait for such a time when this employee can perhaps show his skill and be able to be compatible with that responsibility and that job, and then maybe the company can confirm him at a later date. We have contracts that are about to expire. These are also simple to manage, and we are telling employers to weigh and to see. Contracts that would probably expire in March, in April, in May, probably are no-brainers, because then it means the contract may perhaps reach its full maturity, and for the employer is just to ensure that the employee exhausts their leave days and the employer is able to meet all his obligations under those contracts that are about to expire. I think the ones that have challenges are now the contracts that have a long time before they expire, and they are fixed term contracts. And as we talk about how you can manage these contracts, we are going to cover those. And of course, it's important for employers to go back and just to see the terms and conditions of service that are contained in those contracts. This also applies to regular contracts, and regular contracts, we're talking about the P&P contracts, the permanent and pensionable, and whether these contracts have in their terms and conditions provision for suspension of those contracts. Most of the time, employers use suspension as a term during disciplinary action. And therefore, when we are talking about managing of these contracts, we are going to really look at what it means to suspend a contract of employment. Many of us, in terms of employers, have asked about frustration of contracts. What does it mean when a contract is frustrated? This doctrine is a doctrine that is found in English law, and particularly English law of contract. We do not have that here. For a long time, Kenya was actually using the Indian laws, the Indian the Indian contract laws, basically, but we stopped doing that, and so we are also not using this doctrine of frustration of contract within our laws. However, when there's a lacuna in the law, or what we call a gap in the law, we now rely on what we call comparative jurisprudence from other jurisdictions, means from other countries. We look at their laws, we look at common law, and see how that can apply. And even sometimes our laws, our cultural laws, which many times we do not hold them in high esteem, but they also are applicable in accordance with our constitution. Therefore, frustration of contracts is where unforeseen circumstances outside the control of the contracting parties prevent the achievement of the objectives of that contract, or they render the performance of that contract illegal, or make it impracticable or impractical, impossible to execute those contracts. And we have to ask ourselves, does COVID-19 render that contract impossible, or does it make implementing that contract illegal, or prevent the achievement of its objectives? And I want us to really open up our minds when we look at this kind of provisions. When we say that it renders its performance illegal, if we look at it in terms of the curfew, or if we look at it in terms of some of the regulations that the government has given, is the performance of a contract of employment then illegal if it goes against those kind of directives and orders of government? When does frustration, the doctrine of frustration of contract, apply? It is important for employers to know that it has a narrow application, and it also has what we call tenets that you must meet for you to say that a contract is now under the doctrine of frustration. The legal consequence, of course, of a contract that is found to have been frustrated automatically terminates. And that's why it's important for us to look at really what are those components that we can say this is a frustrated contract. And then, of course, the contract, the doctrine of frustration, a contract is not void ab initio, means it is not from the beginning void and unimplementable, but it only happens when that situation comes, and the employer now for future obligation is unable to discharge his obligations under that contract. So that is something important for us to note. We've also had a lot of questions around force majeure, and this is about to see whether COVID-19, whether that pandemic is really or falls under force majeure. This is an act of God or an act of man that is unforeseen, unforeseeable, out of reasonable control of parties to contract, which makes it objectively impossible for one or both parties to perform their obligations under the contract. So force majeure should be contained in the terms of the contract ordinarily. But I know many of us, we already have contracts perhaps that don't cover a clause that covers force majeure. If an agreement does not contain this clause, then we rely on common law, as I had said earlier, and the principle of supervening impossibility of performance to suspend obligations under that contract, provided that it has become objectively impossible for them to perform the contract or their obligations under that contract. I want us to look at some of the issues or some of the things that you're able to detect or to what constitutes this force majeure. These are events that we have said beyond the control of parties. They are unforeseeable, they are unavoidable, they are irresistible. There's nothing you can do about it. Then what makes performance of the contract impossible? This should not simply be that it is difficult or that it is more expensive. This means that it's actually beyond implementation or beyond to the control of parties. Then it should not be directly or indirectly caused by the party, means none of the parties should have created that situation. I can confidently say that COVID-19 was not caused by either of the parties when we look at employment contracts. Then notice should have been given or should be given to the parties, especially the weaker party. And this is where we say employers, you have to come up and take your place, your space in giving proper notices to employees. It looks like it's obvious, but it must be really brought down into writing, where an employer really communicates to his employees and tells them that we have COVID-19 pandemic and therefore ABCD in respect to how you're going to manage that employment contract. And of course, the affected parties must take steps to mitigate the impact or consequences of force majeure in the event on the performance of the contract. And I want us to remember what the president said about when he first made his announcement about COVID-19. He said, those who can work from home, let them work from home. So we can't just say this COVID-19 pandemic is force majeure. We have to look at the practicability and whether it causes it to be impossible for parties to really meet their obligations. So looking at the different kind of contracts and looking at these issues that many of us have been calling for or asking about, frustration of contract or force majeure, we have to look at what in our law allows us to adapt different strategies and approaches. And I want to refer us to section 10.5 of the Employment Act. This section provides that where there's any matter stipulated in subsection 1, subsection 1 basically talks about particulars of employment, where this changes, the employer shall, in consultation with the employee, revise the contract to reflect the change and notify the employee of that change in writing. Means we cannot just agree to change the terms of a written contract verbally. They need to be varied and changed and put in writing so that each party understands what change has been effected in their contract. And therefore, looking at the aspects that we've looked at in terms of force majeure or in terms of frustration of contracts, especially where we do not have a clause in that agreement that talks about what happens when these things come, then we look at the provisions of our laws, that's under section 10.5, and see how we can look at the changes that can come about in the contract of employment. Let me just stress a little bit because it's important to talk about the consultation bit. Consultation may not necessarily mean that you have both agreed, but it means that you have an opportunity to address the issue to the employee and allow the employee also to give their views, because a contract is an agreement between two parties. So those two parties need to meet. And when I say meet, it means virtually, by phone, via email, but there needs to be some form of consultation where the employee can also give their views on what should happen to their contract of employment. And then the employer can communicate to the employee that having considered their views and having considered what the management can do, this is the decision that the management is taking in respect to the different variations that may happen in their contract. So let's look at some of the questions that many of us have been asking, and these are around leave. Can an employee go on leave? Yes, they can. Can they be sent on unpaid leave? Yes, they can, if they have exhausted their earned leave. And can leave be given in advance? Yes. Just the way you can give salary in advance, you can also give leave in advance, meaning that post-COVID-19, the post-COVID time, you will require the employees now to come hit the ground running, and perhaps at that point, they may not really, it may not be a suitable time for employees now to earn leave and take their leave. So they can actually enjoy their leave in advance. And of course, we look at the provisions of the Employment Act, which advises employers that even when you're giving salaries in advance, you're not supposed to give salary beyond 2 months period. So there's also a limitation on how much you can give in advance in terms of leave. And it is wise for employers to also ensure and keep in mind Section 28, which talks about how employers can handle leave, so that you also don't give leave in advance for 5 years, for example. That would be wrong, and I think it would be an unfair labor practice. So it's important that also what the actions that we take at this time are actions that are preserving the employment relationship, but on the other hand, they are also protecting the employer from liabilities that may arise out of these leaves. Then we look at the working hours. Remember, Section 10 of the Employment Act, and a lot of provisions when we talk about an employer's obligations towards an employment contract, some of those obligations are you are the one giving the work, you're the one also who gives the working hours, you're the one who gives the workstation. So it is quite okay for an employer to say work from home, because the employer has a say in the working hours, the working station, who you report to, and so on and so forth. But because we are dealing with contracts that already exist and already have provisions, you may need to vary those working hours. You may need to vary the workstation. You may need to vary whom the employees to report to, perhaps because of the kind of technology we are using at the place of work. And these things, as I said, we look at Section 10.5, and we can vary those terms and say, now from now on, because of COVID-19, we are going to look at a different way of working, different structure in terms of working hours, and of course, that may also affect the pay. And remember, pay of salary is earned. Payment of salary is earned, and we're talking about basic pay. Therefore, the obligation of the employer is to ensure that for those who are working, they are paid in accordance to the hours of work that they are working. It's an unfair labor practice just to say that because there's a pandemic, that people will work, but they will not be paid. That will be something that the employer will owe the employee, if at all they agree on half pay, for example. But that other half pay will have to be compensated when the employer is able to make his money. And this is because the underlying principle here is that services rendered are paid up services. So in the case where you're sending employees on home on unpaid leave, then in those cases, then there is no service rendered, and therefore perhaps the payment is therefore not there. Before we go to reduction of wages, it's important to look at what the obligations of our employer are when it comes to house allowance. If we have to maintain an employment relationship, it means that there are obligations of an employer towards an employee that are contained in the law. Things like house allowance, for example, the law already provides under section, I believe it's 31, that an employer should provide sufficient housing or accommodation or rent. And for many who have what we call a consolidated pay, then there is the 15% that is what we call house allowance. Therefore, can an employer really escape the payment of some of these, what I would call statutory entitlements to the employee? And it is important for employers to note, even with statutory deductions, social protection benefits like NSSF, NHIF, what happens during this pandemic period. And so it will be interesting to see the kind of interactions that we will have this morning, even arising out of these questions. Then, of course, reduction of allowances and other benefits. There are many allowances employees enjoy: telephone allowance, transport allowance. Of course, during this pandemic time, when employees will be at home, some of those allowances will not be payable, basically because they are expendables. What we mean, they are expenditures that are spent in the carrying out of the work. And therefore, if an employee is not at the place of work, then he'll not be entitled to this kind of allowances. And of course, overtime and so on and so forth. We've gotten some questions from some of us who are talking about lunch break. Can we reduce the lunch break because the working hours have been reduced? Again, remember, working hours and all that are managed by the employer. And looking at section 10.5, we can actually vary those terms of engagement and negotiate with the employees on how we can practically work with the kind of working hours we have, even during this pandemic period. So we're going to open it up to questions and answers. There are quite a number of questions that have been coming, but we want now to open this session to members so that they can ask the questions that they want to ask and that we can be able to answer them. So maybe at this time, I will invite you as our members to ask your questions, even as we answer some of the questions that have been asked previously. So even as we look at your questions, I want to hand over to my colleague, Mr. Ombok. Moses had some questions that he had received earlier that I would like him to answer, even as we receive your questions during this interactive session of question. To you, Moses. Karibu sana.
Thank you, Madam Grace. Again, we are saying that was a wonderful presentation. Now, participants, what I would like to take you through is now a matter of so many questions that you had asked before. Okay. The first concern was about what happens when an employee has exhausted their unpaid leave, and therefore the employer has nowhere to go with this employee. Remember, you have to maintain employment contracts. You will need this employee after the COVID-19. And therefore, what you need to do is to look at how many options do you have. If you go for the worst option, that is layoffs, which we do not advocate for, then you should have a contact of this employee so that in future, you can bring them back on board when the situation has improved. The other question was about how the employer can deal with wages increase arising from a CBA during this pandemic. I'm happy my colleague, Madam Grace, has taken you through the provisions of Section 10, subsection 5 of Employment Act. I would like to add that you also need to invoke Section 27, which gives the employer the right to regulate the hours of work. If you look at Section 27 of Employment Act, and read this together with your CBA and your recognition agreement, which encourages the principle of social dialogue, consultation, exchange of information, and negotiation. This is the point at which you call in the union and you let the union understand that under the circumstances, you cannot afford to increase the wages. And therefore, you are looking at the survival of the employees in employment and also the survival of the business. And then this is the time that you can suspend or rather put on hold the wages increase arising from the wages review clause in every CBA. The other question that members have asked for a long time is when it comes to reduction of wages, how then do you deal with the reduction of wages? What items in a wage should you look at? We encourage you to look at the reduction of wages in terms of the basic salary and see how you can play around with allowances. For example, house allowance. We would not encourage you to touch house allowance. Remember, this employee is living in a rented house. Remember, this employee could be living in your own accommodation facilities. Does it mean when you send them on unpaid leave, then you ask them to move out of the accommodation facilities? You would not do that. So our advisory on this is that you reduce the wages, but then you look at other benefits that you can maintain to maintain a relationship between you and this employee, considering that you have invested in this employee and you would not want to release them to the labor market and lose out, especially when they are out there without any legal glue or contractual glue between you and them. The other question that has arisen from members is about how then do you communicate with these employees even after agreeing on the reduction? The agreement should be reduced in a form of a memorandum where you are writing to the employees and you are referring to the discussions you have had, where you are talking about the mitigating measures that you would want to take to save the organization and also to save the employment. We are talking about how best can we save employment in this scenario. And that is where now you put it in writing and you communicate to the employees for records. Do not just agree and leave it without a written document that you agreed on reductions, you agreed on unpaid leave for the purposes of mitigating the negative effects of the coronavirus. Thank you. I would therefore like to hand over to my colleague, Madam Grace Kanyeri, unless there are more questions that I would want to deal with. Thank you, Madam Grace.
Thank you very much, Moses Ombo. Those are some of the questions we had received during the week. I can see Sarah is raising her hand, or Maya. Sarah, please let us know what your question is.
Okay, my question is, yes, the salary cuts that that we would implement as employers, when the situation resumes, are we obligated to pay back? Let's say if you had done a 30% cut, will I have to pay back the arrears?
Yes, thank you very much, Sarah, for your question. Perhaps allow me to say and to ask, is the employee working during this time of the salary cut? Sarah,
yes,
is the employee working?
Yes, the employee is working.
Thank you. So in a case where an employee is working, then remember, salary is earned, and it means if they are earning and they are earning on a pay cut, the pay cut can only be a result of maybe the less working hours, so that you're paying actually for the number of hours an employee is working. If not, then it means the employer actually owes the employee for the hours that the employee has worked. So you cannot say that somebody is working, but we are going to pay you half of what you usually earn. It's either driven by the number of hours that the employee either has reduced, but if they are working, let's say the 8 normal hours, but you are cutting their pay, then it means it's an amount that the employee is owed. Even though they may agree right now to agree to a pay cut, but in future, it means that that amount is payable to them because they have earned it by way of giving their labor. However, if they agree to a pay cut by way of varying the terms of contract, perhaps because of performance issues, because many employees have performance contracts that say that you're going to be paid in accordance with the performance, then it is a balance that the employee and the employer will have to agree. And as we said, Section 10(5) varied the terms of contract in accordance with the prevailing times. So you pay an employee as per the hours of work that they're working, and of course the output that they're giving. And if you're causing them to work just as hard, then it means you will be owing them, because that is the fair labor practice. So for best practices, we are telling employers to see how they can manage, and of course in consultation with the employee. And then once they agree, then that agreement will definitely should be writing, and it will be honored by both parties. There is also a question that we have received on fixed term contracts. Under the question and answer session, we've seen a question on where in a fixed term contract, the contract has a clause providing for termination on a month's notice. Can the employer terminate on the strength of this clause? We are encouraging employers, and we're telling employers that please remember, termination of employment must have grounds for termination, and COVID-19 pandemic is not necessarily a ground to terminate. There must be overlying issues that cause termination of contract. And then there's a different way of terminating in terms of there are different kinds of termination. If you look at Section 43, Section 45, where they say that the employer must prove the reasons for termination. Is it on grounds of conduct? Is it on grounds of medical? Is it on grounds of redundancy? What are the grounds for this termination? Because you must have grounds for termination. Number two, there must be a fair process. And this fair process is contained in Section 41. You have to meet with the employee. You have to afford them a hearing, even if the hearing is by Skype. And there must be minutes to that hearing so that you can be able to prove that there were reasons and there was a hearing, and that employee was given a fair chance to defend himself in case of conduct, an issue of conduct, misconduct, or something like that. And then, of course, the payment of terminal benefits. So yes, you may have a clause, but that clause must comply with the prevailing laws when it comes to how you can execute that provision. There is also a question which is asking about to confirm what is the maximum period for unpaid leave. I want to give my colleague, Mr. Ombok, this question to respond to. How long is a period for unpaid leave? Mr. Ombok, tafadhali.
Thank you, Madam Grace. Thank you, Madam Grace. The law has not specified how long unpaid leave should go for, but we encourage the employers not to go beyond the simple reason that you can only give leave in advance for at least 1 year. And the annual leave for most employers is up to a maximum of more than 1 month. Then you as an employer are giving yourself an obligation that you will not be able to handle, especially when the situation comes back to normal. You are running your business, and the same employee comes back and is keen on separating from the employment contract with you. You will not be able to handle this. So we encourage that you do not go beyond 1 month. Thank you, Madam Grace.
Thank you very much, Mr. Moses Ombo, on answering that question. We also still have other questions. There's somebody who is asking that we need to understand that affected by the current dull and uncertain business environment, if we want to relieve some of the staff, does it require to follow normal disciplinary tools, or there are special provisions under the circumstances to do it without individual case justification? Remember, we said that in termination of our laws, the Employment Act, when we talk about termination, there are different reasons an employer can terminate an employee's employment. Some are on conduct, whether there is gross misconduct or misconduct, misdemeanors at the place of work, which call for disciplinary action. However, there are others that we look at, like redundancies, which there's no fault of the employee. But disciplinary, termination on redundancy, there's a process. There's a process contained under Section 40, where you need to notify the Ministry of Labor, you need to notify the union if these employees are unionizable, and so on and so forth. And you must give your reasons for declaring the redundancies and the extent to which this redundancy is happening. So all these things, they are procedures. It's not just saying that there's a clause that says terminate, but you have to look at what procedures will prevail at this time. And those reasons, for example, if you decide to go the way of redundancy, you must give reasons that are reasons in law. You can't just say that there's the pandemic COVID-19, and therefore we are declaring redundancies. No, there must be legitimate reasons. You must be able to demonstrate that there are reasons to terminate on grounds of redundancy. And I want to give an example. There are people who are benefiting, perhaps, and they're doing business is now good because of COVID-19. So COVID-19 pandemic in itself is not a ground to declare redundancies. So it's important for you to know what kinds of terminations are these. Are these terminations because of on medical grounds? Are these terminations on misconduct or on conduct, or are these terminations on redundancy? I can see Jack Shihundo. Jack, please ask your question. Jack, can you hear us? You are raising your hand. I think Jack has disappeared. Jack, perhaps you can unmute yourself.
Yeah, I'm trying to.
Jack,
sorry.
Can you hear us?
Hello?
Jack is raising his hand, but we can't hear him.
Okay.
Oh, sorry. Jack, I know I can't hear you. Tell me now, Jack, I can hear you. Sorry.
Okay, yeah. Sorry, Grace. Now, my question is in regards to a provident fund.
Yes.
In a case whereby the organization has one, and the employer and the employees both contribute.
Yes.
Can we be able to suspend it for a certain period just to cushion the employees at this time? And does the RBA regulations, what does it have provisions for this?
Yes, with regard to Provident Fund and social protection benefits like NSSF and so on, which whether we can suspend them or whether we should continue paying them. Remember, because some of these schemes have rules. They have rules and they have regulations. You have to look at the rules because most of these are bound by contract. They're bound by sort of what we call contracts. They have rules and regulations. We have to see the provisions of those rules and regulations and what they provide for. And if they do not provide those breaks, then it means you'll need to get in touch with that institution that is taking care of that pension, because we have different pension schemes that take care, that have different rules and regulations, and then get into an agreement with them. It's not just about now the employer and the employee, but also this third party organization that you have entered into some form of contract with, and you'll need to contact them so that we see. And I believe every company, every organization is struggling with this COVID-19 pandemic, and therefore it's important for us to be able to see how we can mitigate that. Okay? So I just look at the rules and regulations that are there, and then we see what can be done with that. So thank you so much, Jack, for that question. There are other questions and answers which we can see. However, our time is basically almost up. We'll still continue to type our answers to you and answer these questions, but I need to get in touch with our executive director who is waiting. She had some closing remarks that she wanted to share with us and with the members. So I want to go back to Mrs. Jacqueline Mugo to address members and just to give her closing remarks. Remember, you can still send your questions and answers. You can still send communication to us, which will be communicated during the week. And many of those questions we'll also address in the next webinar. So karibu sana, Mrs. Jacqueline, kind We can't hear you. We can't hear you. We can't hear you.
Can you hear me now?
Yes, we can. Please proceed.
Yeah, I was saying my closing remarks are very brief, so we could actually have done one more question, but that's fine. We'll answer them online. I just want to close with some takeaway messages and some key themes which have arisen from our conversation. It's amazing how time flies. The first from the presentation is that there are very many different types of contracts. If you're looking at the employment relationship, and that specific contract and the terms contained in it will determine how the obligations and the rights of the parties and how it can be terminated, if at all. We have also seen that the element of frustration of contracts has come in, and what Grace was calling force majeure, which is a Latin word. But the parties, in terms of force majeure, would really have had to include a specific clause in the contract to cover that. So maybe we're looking at a situation where none of the two parties to the contract of employment are at fault, but are not able to fulfill the terms. The employer is not able to fulfill the terms because the employee is at home. Some work can be done at home, but there are jobs that cannot be done at home. For instance, if someone is a driver, he's either at work driving, or if he's playing a support role, it then becomes very difficult. So I think each specific case depends on the specific job and what can be done from home, in which case we have encouraged employers to facilitate that working from home arrangement. But what I'd like to stress is the element of dialogue and discussion and cooperation in this specific situation, because no one foresaw the kind of disruption that COVID-19 has brought to the world of work. We're in this together, as employers, as workers, as business people. So we need innovative, flexible approaches and usual tolerance on both sides. And that is why we have spoken very strongly against immediate terminations or redundancies, because we have to stick it out until it becomes clear that a business has no other option, in which case all the approaches and the various options that Grace outlined come into play, but fair process must still be followed. This unusual time doesn't mean the rule of law has flown out of the window. We still stand for fair labor practice as employers, but we're also still very keen to see the element of sustainability of enterprises, because recovery from COVID-19 will, to a very large extent, depend on the ability of enterprises to survive and to absorb people back into employment. This is why FKE pushed very strongly for support and some relief to be given to business, which the government did, but we all know it's not enough. And in fact, the tax amendment bill has plowed back some of what the government had given. So there is need for discussion, and for us as a country really to assess what is it that the government gave in terms of tax rebates, what is the tax amendment bill seeking to do. At the end of the day, is their gain. Because if you give those earning less than 24,000 shillings tax reprieve, they don't pay as you earn, but you increase the cost of essential items like power, fuel, food, then at the end of the day, they don't really gain. So I think that's a conversation which will continue. But in terms of the employer-employee relationship, the employment contract, we still advocate for fair labor practice and unusual tolerance, even on the part of the unions, because for you to suspend the application of a wage increase in a collective bargaining agreement, which we'll be talking about in detail with trust, the union needs to agree. There needs to be a signed document, which is an addendum to the existing collective bargaining agreement. If there is a reduction in pay and there is no union, or even if there is a union, there needs to be a clear agreement as to whether that reduction is temporary and the employer should pay back, or whether the employee will be reimbursed for whichever portion of pay he or she hasn't got when business picks up. Of course, when business picks up is also another debate, because it can't be immediate that if we were to resume work in July, because everybody's talking about a 3-month hiatus, which could actually extend beyond that, then you can't assume that in September the employer is ready. So these are elements of conversation. An employment contract is negotiated between the employee and the employer, in some cases between the union on behalf of the unionizable staff and the employer. So the variation of terms also needs to be negotiated. So the key words at this time are tolerance, negotiations, fair practice, and then cooperation for us to deal with the COVID-19 crisis that we all find ourselves in. We want to thank you all very much for your participation in this second webinar. We will be answering the questions that were not answered directly through this session, and we hope to engage you next week on a different topic. Have a good week. Kwaherini.
Thank you, our Executive Director Kwaherini. Members, we will keep you informed of the next webinar. Goodbye.